Hi, everyone. We're going to get started in just a minute. We'll give it a few minutes for folks to get to join the webinar. Welcome to our presentation, and we'll start in just a minute. All right, I think we'll get started. So I want to thank everybody and welcome to the League of Women Voters January 2023 Lunch and Learn program. I'm Robin Schmidt. I'm president of the League of Women Voters of the La Crosse area. And I want to thank you for joining us today to hear from Lisa Graves discuss what's undermining our courts and to explore how to repair and strengthen public confidence in our Wisconsin judiciary. With the primary election less than a month away, which includes a race for the state Supreme Court, it's really important for us to understand the various influences in our judiciary. I always give a little brief update about the League at the start of our programs. Our mission is to empower voters and defend democracy. We are a nonpartisan political organization, and we encourage informed and active participation of citizens in government. We work to increase understanding of major public policy issues, and we influence public policy through education and advocacy at the local, state, and national levels. We take action on public policy positions established through member studies and consensus. As an organization, we never support or oppose any political party or any candidate. What we do, however, is try to make sure that our members in our community have access to information about issues and elections and share for you ways that you can take action. And one way we do that is through our website. So I would like to just take a minute here and share a picture of our website. Basically, I wanted to point out that we have two new things on our web. We now have what we call a member hub web page that has information about the League, sort of as a one-stop shopping approach, so to speak. You can learn about the League, about our positions, various teams and volunteer opportunities, all in one spot. And I want to mention that right now we are still looking for a couple of volunteers to help with our Vote 411 voter guide. So if you have some time and can serve as a contact for local candidates, we'd love to have you join our group. Also, if you're considering, if you like what we're doing and you have some time and want to be more engaged, consider serving as an officer on our board. It's a lot of fun and extremely rewarding. So visit our member hub to contact us with any of your interests. But also, and almost more importantly, we also have revised our homepage to include a link to a new web page that we have that is dedicated just to fair courts. So we have a plethora of information there. We've got links, we've got recorded programs and other resources relating to fair courts, and we'll be keeping that updated as we go through the spring. So please, I hope that you'll consider that a resource for you to find information on this topic. We also link to the League of Women Voters of Dane County's recent program on constitutional amendments, especially in light of the legislature voting to add another amendment to our Constitution on our ballot for this spring. So if you want some more information on those amendments, go to our homepage and there's a link there for those constitutional amendments. I want to give a really big shout out to Nora Garland for her tenacity, research, and expertise in putting the website together. She does an amazing job, and we're really lucky that she dedicates her time to the League. So thank you, Nora. For today's presentation, we're going to ask that you type your questions into the question box as you have them for Lisa. And then we will have time for a few questions at the end of the presentation. I also want to remind you that the program is being recorded and it will be available on our website, again, thanks to Nora's magic, It's usually there by this evening or tomorrow morning. So if you want to reference this, please feel free to share that our website with anyone you think might be interested in this program. So thank you again. I'm going to turn it over now to Ellen France, who's with our program committee, to introduce today's speaker. So Ellen, take it away.
Thank you, Robin. In February and then in April this year, we have elections for our Wisconsin Supreme Court, primary election in February and the regular election in April. It's an opportunity for citizens to voice their commitment to fair and independent courts. Some of us think that some problems that exist in elections involving our justices are money, donations, large money, dark money, and weak recusal rules that are operating to undermine our court. I'm pleased to introduce today Lisa Graves, who is the Executive Director of True North Research and a graduate of UWL and Cornell Law School. She previously served as Chief Counsel for nominations for the U.S. Senate Judiciary Committee, as Deputy Assistant Attorney General in the Office of Legal Policy of the U.S. Department of Justice, and other posts. Her analysis has been cited in every major paper in the U.S., and she has appeared on numerous TV programs and testified before Congress. In March 21, she submitted testimony to the U.S. Senate Committee on the Judiciary, Subcommittee on Federal Courts, Oversight, Agency Action, and Federal Rights. What's wrong with the Supreme Court? The big money assault on our judiciary. She has also been featured on Showtime and in documentary films like Ava DuVernay's The 13th. Welcome, Lisa.
Thank you, Ellen. Thank you so much for that introduction. And it's genuinely such a joy to be invited to this event. Thank you, Ellen. Thank you, Robin. Thank you, Deb, for your technical support as well, and the League of Women Voters of La Crosse and in Wisconsin. Today, I'm going to present to you some information that my colleague Evan Warple and I have been working on for some time now. I'll begin with more of a national overview, and then I'll pause for a moment to go back to about a decade ago to sort of show you some of these trends, and then we'll talk about some of the current groups that we're seeing in these fights over our fair courts, and then we'll have time for questions and answers. So I think that I can share my screen if I minimize this. Will you tell me if you can see this? Can you all see my screen?
No.
Okay. All right, hold on, let me do this one more time. A little technical difficulty there at the beginning. Here we go. Can you see it now? All right.
Yep, looks good.
Okay. All right. Okay. So thank you so much for taking your time out of your day today to come to this webinar. I really thought quite a bit about even what to name this webinar, in part for my presentation, in part because of the way that some of the language around fair courts is being used by dark money groups, namely Fair Courts America. So I would ordinarily say the battle for fair courts, but I had to say the urgent battle for genuinely fair courts because of the way that language is being deployed. So I'm going to focus here on Wisconsin. I do live in Wisconsin. I am a Wisconsinite, and we also do a lot of work around these issues nationally, as Ellen mentioned. So this is who we are. We do a lot of work with the media, as Ellen mentioned, and one of our focal points is these dark money, the way that dark money is being spent by reactionary billionaires, in my opinion, and front groups in states to really distort our courts. And I'll tell you more about why I think that, why that's my point of view. So, you know, it's obviously the case that people in general in America have a belief in fair courts, the need for fair courts, the idea that you should have a fair and impartial judge who decides cases. That just seems like a bedrock principle in our democracy, but it's not always the case. And in fact, there's been a lot of money spent, in my view, to make sure that the people who are deciding in these cases aren't fair, that they're sort of pre-chosen to make sure that they're going to change the rules. In fact, the very rules of our democracy. But our democracy is not just a theory or a form of government. It's actually a mechanism for protecting or advancing values. And almost every issue now that we face in American society ends up in the courts, whether it's the US Supreme Court or state Supreme Courts like the Wisconsin Supreme Court. That includes voting. It's going to include climate change issues. It's going to include the abortion issue and more. And so there's a lot at stake about whether we have judges who are fairly going to follow the law, follow legal precedents, or whether they're going to put their thumb on the scale of justice to try to advance a political agenda. In my estimation, as I'll talk with you about, a very sort of extreme agenda is one that's being heavily funded. Who are the villains of fair courts, in my view, and what are their tactics? And again, this is not a partisan issue. The court races are nonpartisan in Wisconsin. It's a question of, as I'll describe, some of the goals or the objectives of some of these deep financial investments by a handful of individuals. So one of the main groups that has been heavily involved in Wisconsin is a group called the Republican State Leadership Committee. They're a group that was involved in what's known as the Red Map effort back in 2010, which was this effort to capture state legislatures, because every 10 years under our Constitution, we do a census, and that helps to provide information for legislatures and for the state governments to draw map lines so that people are fairly represented. Unfortunately, the objective of Red Map was the opposite in essence. It was to capture these state legislatures to draw the most partisan sort of right-wing maps possible. So if you've heard of RSLC, you probably have heard of them through this Red Map effort, which was quite successful in 2010. And in fact, that 2010 effort to take over the Wisconsin legislature and governorship and other states continues to have effects on the current maps in Wisconsin in 2020, because once you have this determination to really, squeeze the maps, it's very, very hard to undo, because it's such a key procedural component of our democracy, and whether we're electing people to represent us or whether they're choosing who votes for them in order to maximize their power. So another key feature of RSLC is that it really is a substantial dark money operation, and the largest donor, as we've been able to discern. Let me move my screen over here. The largest donor that we've been able to discern through the filings of RSLC with the IRS over the last several years are Leonard Leo tied groups. I'll talk about him in a minute, but I'm sure you've heard of him. He's been called the Trump judge whisperer. He was central to choosing who Donald Trump chose from for the US Supreme Court. But that's not all, as you'll hear soon. RSLC also has a lot of corporate funders. That includes Koch Industries, one of the biggest, richest corporations in the world, Marathon Petroleum, Pharma, Chamber of Commerce, and others. RSLC also has created a thing called the Judicial Fairness Initiative, but the only donor to the Judicial Fairness Initiative is RSLC. So it's another way to hide the money, to kind of have this shell game that's being played. So, I made this particular graphic or a version of this before the news broke last August about the person in that question mark, or at least a person in that question mark. And that was, an effort to try to describe, well, what is this money that that Leonard Leo is involved in? How does that get to RSLC? How does this really work? And because it's dark money, we didn't know who the major funders were. We knew, for example, that Charles Koch had said in material that we posted on our Koch Docs, KOCHDOCS.org site, that Charles Koch was funding Leo's efforts around the Supreme Court, but we didn't know, for sure it was a substantial amount of money, who those major donors were. So I had this question mark, this guy with a question mark. And then we knew that money was going to the Wellspring Committee that now is defunct following its role in the Supreme Court, US Supreme Court efforts in 2016, 2017, 2018, actually going back to 2010. It's now, it sort of was subsumed by not legally, but another entity popped up called the Rule of Law Trust, which was then giving money to the Judicial Crisis Network, which I'm sure you've heard about because of its role in these battles of the US Supreme Court, which then has rebranded as the Concord Fund, again, with this sort of disposable names of organizations thing, which then gives money to RSLC, which then gives money to JFI. And of course, JFI is RSLC. So I saying that just verbally without the video, I think it would just be like acronym salad, but I'm trying to show how these different entities relate to each other. And there's more to that story. So let's see. So Judicial Crisis Network, Concord Fund has received more than $120 million as part of Leonard Leo's court capture group. The Washington Post documented that in a story in May of 2019 by Robert O'Hara and Sean Boberg. It's since been updated. Devin and I have updated those figures. But one of the things they've done is that they've attacked Senator Whitehouse, who has been at a center point at the national level to exposing this scheme, and has written books about it. In the midst of all this, we were doing some other research, and we discovered that there was this billionaire in Chicago named Barry Side, or Barside, who was funding this group called Consumers Research. We discovered that he was the anonymous funder in part because there were materials from the Bradley Foundation, which is the biggest foundation in Wisconsin, which operates out of Milwaukee. And those materials became public in late 2016. And those materials revealed that this billionaire in Chicago had been working with the Bradley Foundation to get money to Consumers Research, but also to underwrite briefs to the US Supreme Court that advanced another group tied to Leonard Leo, the Republican State Attorneys General Association. So I just popped that in there because he becomes important later on. We know that he's been funding anti-choice, anti-climate change mitigation, anti-regulation. And then it turns out that he is now the biggest known funder of Leonard Leo. He has given money to Leo's operations, which have been involved in focusing on the US Supreme Court, as well as state Supreme Courts. And that includes efforts to try to overturn access to healthcare, efforts to mitigate climate change, and much more. So now we know it's not just that, that the network that Leo's created has, hundreds of millions of dollars. We know that Leonard Leo's network to PAC, the US Supreme Court and other courts, has received more than $2 billion since 2014. Like, that is just a huge sum, admittedly. And based on the amount that is in reserve, in essence, more than $1 billion in reserve now. If Leo were just to deploy the interest or the earnings on that $1 billion, he could spend, in excess of 150 million to $200 million a year, assuming, sort of general rates of return. So it's a substantial amount of money, but he's not going to be deploying it as Leonard Leo, or necessarily even through the groups that we know. It then gets filtered through the other groups, which brings me to this slide. So now we know the identity of one of these major funders of Leo. It's Barry Side. They created a thing called Marble Freedom Trust, which ProPublica and New York Times Magazine broke the story on last August. They then give money to the Rule of Law Trust, to Schwab Investments to filter money to grantees, to a thing called American Engaged, to another donor advised fund called Donors Trust. They then give that money to, I don't know if you can see that at the top, JCN, Judicial Crisis Network, Honest Elections Project, and more, which then give money to RSLC, and it comes to an election near you. So that is the sort of a picture of that, how that operation seems to work. Why do you care? Why should someone care if there's all this money floating around the courts? What's in it for Leonard Leo? What does he want? What are his objectives? We know that he was previously the vice president of the Federal Society, and he now helps lead the board of the Federal Society. We know that he's very anti-choice, anti-LGBTQ rights, but there's more. He was at an event for the Council on National Policy in 2019. This was covered in the Washington Post story. And I'm just going to read it because I just think it's important to understand, or at least I'll synopsize it for you so you can see the whole screen. But in essence, he's saying to this group of donors, a closed door meeting of donors, that because of these appointments to the U.S. Supreme Court, the United States is at the precipice of what he calls a revival in what he in other places describes as the structural constitution. And he says, I don't think we've seen anything like this since before the New Deal. No one in that room had experienced the kind of transformation we're beginning to see. This is before the Dobbs decision last year, before some of the other decisions. What he's describing is an effort that has been, elaborated on elsewhere to reverse, nearly a century of legal precedents, 21st century and 20th century legal precedents. We see that in Citizens United, the decision in 2010 that dramatically changed the rules in our democracy. Again, a procedural focus that has dramatic long-term effects to expand or at least limit the ability of Congress to regulate this dark money that's flooding our elections that now has become a tsunami. We see that in the voting rights case that the US Supreme Court issued that Chief Justice John Roberts himself wrote, where they basically took out a key portion of the Voting Rights Act's enforcement provisions that has helped unleash this very virulent effort to make it harder for Americans to vote and limit the ability of the Department of Justice to intervene or stop that from happening. We've seen that in the redistricting case, the Common Cause versus Rucho case, where the Supreme Court intervened to change the rules and say to limit the power of federal courts to protect people from extreme partisan gerrymandering, as we've seen in Wisconsin and North Carolina. In that case, the Supreme Court said, but of course, people will still be able to pursue those cases in their state Supreme Courts. And now this term of the US Supreme Court, we see this court with additional Trump appointees, the US Supreme Court, saying that considering whether to block even state Supreme Courts of having any oversight over these maps. So it really represents an extreme agenda. And the other part of this that I just want to pause on is that, there's obviously money happening with democratically aligned groups and Republican aligned groups around judicial appointments as well as Supreme Court races. But for me, one of the things that's most dramatically different is how much of the money is being spent on the right around judges who are getting on the court to reverse precedents, to change the law, to change the course of American history, not to follow precedent. Typically, over many decades, you would hear judges say in their confirmation hearings or at debates, I believe in following precedent, I support precedent, precedent is important. But what we've seen is this new brand of judicial nominees or judicial candidates who have been blessed by Leo or supported by Leo's network, who appear to be being chosen or supported because there's a view that they are going to change the rules. And we can see how that has happened in Wisconsin, which I'll talk about shortly. So I call the Leo groups, or many of the Leo core groups, front groups. And here's why that's my opinion. They don't have a website. What kind of group has $1 billion and doesn't have a website? Marvel Freedom Trust. They don't have any real address. They use people's personal houses or mail drops. They don't even have a real phone number. Many of Leo's groups go to the phone number of a guy named Neil Corkery, who's notoriously anti-choice and anti-marriage equality. And there may even be some double dipping. And I don't mean that in a legal sense, but in illegal sense, I mean legally reporting that some of these groups then contract with the for-profit firm that Leo is now helping to lead, CRC Advisors, for polling and advertising support. So you have money coming in on the one hand where Leo is being paid directly from Marvel Freedom Trust as the primary trustee to direct money to these other groups. And then those groups direct money to other groups. And then those groups end up hiring Leonard Leo's for-profit advertising and political advice firm to help them with their agenda. So this is another example of how RSLC spends money under the JFI brand. Money comes in from Leo's Concord Fund or Judicial Crisis Network. It also comes from another group that's tied to Leo. And then you have some other corporations that give money. But Leo's funding overall is greater than even Koch Industries' support for this effort that's targeting our courts. So what does RSLC do? Because it is the state leadership committee, it's focused on the states, and Wisconsin has been a particular target of RSLC. One, it typically does what I call a cash bomb, which is $1 million scorched earth ad campaign, often social media, in the last week before the general election. So the money comes into RSLC after the primary, then RSLC typically transfers the money to JFI, RSLC's JFI. JFI then reserves ad time, or reserves, if it's a TV ad, or cuts the ads, prepares the ads, the attack ads against their opponent. And then the week before the election, they just spend a huge amount. Now, $1 million in another state might not be a lot to spend in 1 week. In Wisconsin, it's a huge sum because, as I'll show you in a moment, in Wisconsin, the candidates themselves usually only raise about $1 million for the entirety of the campaign. So for an outside group to come in and dump $1 million on the eve of the election, attacking their opponent, the opponent of RSLC, is significant, and I think it has had a significant impact on these recent Supreme Court races. That leads me to part B, which is, they engage in what I consider to be smear campaigns in some places, in some states. They've been called out for their ads, for the tenor of their ads or how misleading they are. Sometimes there are sort of racial dog whistles and other things that are used that are typical of these sorts of smear campaigns. A third component is often the people that are being promoted, not the people who are being attacked, but the people who RSLC are trying to help just happen to be Federal Society lawyers or frequent flyers at the Federal Society, Leo's operation, and they are always branded not as activists, but as rule of law judges. But rule of law means something very different to them and to Charles Koch. It means basically changing the rule of law in dramatic ways that without talking to the American people about what their real agenda is. And then, as I mentioned, with these smear campaigns, they brand their opponents as liberal judicial activists and that sort of thing. So that's the sort of game plan that we see. So let's take a look at Wisconsin. Leo has been involved in Wisconsin Supreme Court races since at least 2011. That may be a surprise to you, and I'm going to tell you more about that in a moment. But what we see in Wisconsin, as with the US Supreme Court, is that there's this cycle that I describe as this dark money circle, where the capture of the court happens through the dark money groups. Then elected officials try to protect dark money from disclosure. And then the right money, anyway, sorry, I should start on the right. The elected officials try to protect dark money from being regulated. These right-wing dark money groups then capture the court. Then the courts tend to protect dark money groups. And we saw that in Wisconsin after Prosser was reelected in 2011, and subsequently, where there was an ongoing bipartisan investigation of Scott Walker, the John Doe 2 investigation. And the Wisconsin Supreme Court intervened to stop that investigation that was under longstanding Wisconsin law, and to basically rewrite the rules for coordination in Wisconsin, which was then ratified by the Wisconsin legislature dominated by the GOP, to then legalize the type of coordination that was the subject of criminal investigation by bipartisan group of investigators. So this chart is a little hard to follow, but I just want to give you a sense briefly of sort of these trends. So you can see, for example, in 2020, how much was raised and spent, and how the outside money groups that aren't the campaign spent money. 2019, 2020, et cetera, et cetera. So you can sort of see the whole thing. The one thing I would point out here is, back in 2015, there wasn't as much money, dark money on the right around the Supreme Court race, but that was because WMC, Wisconsin Manufacturers and Commerce, spent nearly $600,000 on an amendment to change the rules to remove Shirley Abramson from being Chief Justice of the Wisconsin Supreme Court. And what happened then was Pat Rogensock was installed as the new Chief Justice. Let's talk about 2011, because it does sort of show the seeds of how some of this works in Wisconsin. So back in 2011, this material is from The Guardian. This is the material that The Guardian published from the leak of the John Doe 2 investigation. And what you see is R.J. Johnson. He's the person on the far right of the screen in black and white. He was Scott Walker's key campaign guy. And he is sending this email to Eric O'Keefe with Club for Growth. Sorry to go into this detail, but it is the same sort of recurring cast of characters, talking about how they've been in touch with Diane Hendricks, one of the richest people in Wisconsin who was very involved in trying to support Walker's election, as well as to stop the recall. And it says she is concerned about the state court, the state Supreme Court. So then RJ Johnson replies to Eric and he says, he himself has raised $450,000. Leonard is hopefully looking for $200,000. That's Leonard Leo. So then he sends an email to Leonard Leo. It's blacked out there because the next email is Leonard Leo at the very top saying, I can see it, but I'm confused about the advertising costs. So here you have, unbeknownst to anyone before Leo is much more famous, the vice president of the Federal Society involved in securing from somewhere $200,000 to help advance Diane Hendricks and the right wing's wish list to keep the Supreme Court in the hands of right wing or conservative. Some might say, I never say that term because I don't think they're conservative, but judges, because they're going to be hearing cases around the Act 2, the effort to undermine labor in Wisconsin and more. And then ultimately Prosser won that race narrowly. So then again, in these John Doe 2 documents that the Guardian published, you can see Scott Walker telling Karl Rove that RJ Johnson ran the effort that defeated the first incumbent Supreme Court justice in decades back in 2008, and Club for Growth, Wisconsin, was key to retaining Justice Prosser. So you can sort of see them in their own words describing how this operation worked. What else happened in that 2011 election? I wrote a piece that year because suddenly a group out of nowhere called Citizens for a Strong America popped up and ended up spending nearly $1 million in that race. The guy tied to it was this young man over here who's like under 30, didn't have that money himself. He was the person who was working at that time for Koch's Americans for Prosperity. The ultimate office of Citizens for Strong America ended up being in the same building as Americans for Prosperity, John Connor's operation within that group. $1 million out of the blue in 2011 in that Supreme Court race is what helped, push Prosser onto the Supreme Court. And that was totally dark money, totally dark money. Who secured that seat? What was their agenda? Okay, so we'll go fast forward now to some of the recent battles with this RSLC cash bomb. I could go through each of them and how RSLC getting money from Judicial Crisis Network or other efforts have been involved, including some of these other pop-up groups like Wisconsin Alliance for Reform called WAR. We definitely have more details on that. We put that in some articles and we'll definitely share those with the league. But these are just some examples that come to the front. You can see how there was support in 2016 for Rebecca Bradley. Judicial Crisis Network transferred $1.4 million to WAR, which was the vehicle that year that was backed by RSLC to support her election. What has she done on the bench? She's been involved in a lot of decisions. One of the decisions that's most maybe notorious or significant is that she voted to make absentee ballot boxes illegal in 2022, which just happened to be urged in court and elsewhere by Leonard Leo's group that is called the Honest Elections Project. Taking a look at 2019, again, you can see this money being spent by RSLC the week before the election. It was $1.2 million. And Justice Hagedorn won by just 5,000 votes. He too joined in that decision to change the rules in Wisconsin to make ballot boxes that had been lawful for a long time illegal and make it harder to do this sort of absentee ballot support. 2020, again, RSLC spent nearly $1 million backing Kelly, most of it the last minute. We know that JCN gave $1 million to RSLC. We don't know that all that money was spent in Wisconsin versus other states. But we do know, again, with this cast of characters, that Charles Koch's Americans for Prosperity also spent nearly $500,000. So these are big sums in races where the candidates themselves raise almost only that amount for the entirety of their campaign through the primary and the general election. They simply do not have the money at the end of the election cycle in reserve to respond to the attack ads, and they couldn't raise it themselves as candidates. They can't suddenly, come up with $1 million in small dollar donations the last week before the election. And even if they could, they couldn't cut the ads and get them placed and get them distributed in time to respond to this scorched earth surge. So what does it look like? What do these ads look like? Let's just take the Hagedorn race example. So they use, this language about, voting conservative. He's a common sense conservative. He's committed to the rule of law. They try to tie this to Kavanaugh, to the Supreme Court. That's the sort of language that they use. And then they also say, you want to stop the liberal takeover. So that's the kind of language that we'll see over and over again in 2023. But now there's a new player on the scenes. Not on the scenes in Wisconsin, because we've seen the U-Lines be very active in Wisconsin politics, but they have seemingly dramatically increased their fortune during the pandemic as people are relying so much more on boxes, which is the core business that they received seed money from Dick's father to launch U-Line, U-L-I-N-E. And the pandemic has made them even richer than before, in a way that's similar to how Jeff Bezos and Amazon has gotten so rich during the pandemic as so many people have struggled. Their products have been dramatic, on the dramatic rise. And what have they done with all this surplus? They are pumping their fortune in right-wing politics. That's not me. That's Forbes magazine telling you that and telling that story. But who is Dick Uihlein? These are newspaper articles or news articles about him. There's been a reporting about how he supported the Tea Party patriots, who were central to the march to stop the steal on the Capitol. That's from the Urban Milwaukee newspaper there in Milwaukee. The Guardian wrote a piece about how as Dick and Liz Uihlein were opposing common sense health protections in Wisconsin to address this deadly pandemic, that the workers at Uihlein's firm were exposed to higher than ordinary COVID rates. There's another report by ProPublica about how the Uihleins have been central to, in their words, providing the funds to bankroll anti-democracy causes around the country. And then we even have an article from the Center for Media Democracy, where which I previously led, and I'm the president of the board, which talks about how Tea Party patriots, it not only was involved in getting people to the Capitol for the wild protests, but also the insurrection, but also have been behind getting pro-Trump doctors to deny the science behind vaccines and peddle snake oil. So it really is like sort of shocking. Like, here's this very rich guy, and he seems to be backing these very extreme causes, including there were reports that he was involved in supporting the protests in Wisconsin against having those having masks. That was the protests that were notorious in Wisconsin for there being a guillotine on our Capitol square, not just the ones in Wisconsin. That's not to say that Tea Party patriots put that guillotine up, but that was part of the optics, the feeling of that attack. People were there with weapons standing around the Capitol, attacking the very idea of having masks to help protect against the spread of this illness. But he's also been supporting anti-choice groups, anti-climate change mitigation, anti-regulation. I put his head on my previous version of Barry Seid, another billionaire spending money in these races. So what is he doing? He's doing a thing called Fair Courts America. So now people in Wisconsin are going to be getting advertisements from Fair Courts America about fair courts that's bankrolled by Dick Uihlein. So let me just pause for a second, because I want to make sure I describe this accurately. Fair Courts America is a super PAC project of restoration of America, which is an Illinois-based 501c4 that is bankrolled by Uihlein. It was launched in February 2022, and it was launched the same day that RSLC's operation said it was going to spend substantial sums in the midterms on Supreme Court races. I'll get to this next part in a moment. I'll just hold this last thought. But here's how they describe themselves. This is from their literature that was covered in a newspaper article last fall. They featured Ted Cruz saying that, I think that unfortunately for the left, the law is viewed as optional. And if they agree with us, they refuse to enforce it. It's just an astonishing quote from a guy who I worked with at the Justice Department, but who I've observed over time, putting forth a lot of disinformation. Fair Courts describes itself as an entity launched by Restoration PAC, the third largest super PAC in the conservative super PAC in the country, and is behind only Americans for Prosperity, which is Koch, and Club for Growth, which is dark money and has historically been Coke. Here's how they've described themselves as well. They say that they're tracking the woke mob's activities and are ready to fight for free and fair courts. So this entity has committed to spending a substantial amount of money, and it already is spending money in Wisconsin. And the co-option of fair courts by this group, the use of that term is only going to spread confusion, I think, among voters about who supports fair courts, what are fair courts, and that could lead to some people staying home, could lead to some people, being misled because, they have a right to use that terminology, to use that name, but it's a deliberate effort to try to own the space of fair courts by a billionaire who, if you look at his track record, seems very interested in advancing pretty extreme ideas, which are not the same as fair and independent judiciary in my view. So now you have RSLC and fair courts as two of the main groups operating in Wisconsin, and it just so happens, the part I held for a moment, Fair Courts America's executive director, Andrew Wynne, W-Y-N-N-E, also leads RSLC's JFI, serving as its vice president for the past 6 years. So, it is, again, these different names are, used, deployed to play a role in these state Supreme Court races. And the names in some ways are very disposable. They're very utilitarian. They may not, reveal accurately what they're about, like the Judicial Fairness Initiative. They describe it as fairness, but it really is advancing, attacking people that they perceive as liberal or progressive, even if they have a history, as we've seen with some of the Supreme Court races in Wisconsin, like with, sorry, I just lost the name in my head, Lisa Neubauer, who'd been a judge for a long time and was well regarded by judges across the state as a fair-minded judge. Doesn't matter if they have a track record of being a fair-minded judge. Lisa Neubauer was targeted by a $1.2 million ad blitz a week before the election in 2019, that she wasn't a fair judge despite her track record of fairness and her support by judges from all backgrounds in general of supporting her. So this brings me back full circle. Here we are again. There's an election near you. Here we are with the spring primary and the general. Highly unlikely that Leo is sitting on the sidelines, but again, we won't know until nearly after the fact, if not after the fact, whether he or one of his groups has sent money in. If they're true to their track record, JCN will be involved in the state. Leo's taken a very specific interest in Wisconsin for more than a decade. And again, the agenda is not one that most people would think is about fairness. It really is about making sure that there are judges who are not a neutral umpire, as John Roberts tried to suggest at his confirmation hearing back in 2005, but people who have an agenda. And so one of the ways you can see that agenda, in my view, is look at the Johnson versus WEC case that this Wisconsin Supreme Court handed down, which set aside maps that were designed to be fairer for Wisconsin and interposed a completely invented new rule that you could only have minimal change from the highly partisan map that the state legislature drew, or it would fail. That rule does not exist anywhere but in Wisconsin and in the minds of these, in my view, right-wing judges that have been put on this court. But you can see the same thing in the Dobbs case, where the U.S. Supreme Court basically rejected nearly 50 years of precedent, even recent precedent, to create a new rule or a new interpretation of stare decisis, a following precedent. And then you could see that in last year's decision around the Clean Power Plan, which was the decision involving the EPA in West Virginia. There's a big story in the New York Times from June of last year about that story and the role of Koch and Leo in that dark money operation to target the court to invent a new rule, which they call now the major questions doctrine. It's not a doctrine. It's just their new way of basically creating a legal invention to try to set aside regulations to try to address climate change. Will the Wisconsin Supreme Court adopt a similar new rule about climate in Wisconsin? Who knows? But we know that the judges that Leo has backed are very interested in imposing new rules, rules that change longstanding legal understandings, including the role of the judiciary within our democracy, as well as changing the rules related to what legislatures can do in ways that have maximized the situation we see in Wisconsin, where you can have presidential races and statewide races that are won by Democrats, but the legislature is still disproportionately captured by the minority party, by the party that cannot win or has not won statewide for the governorship recently, previously for Obama, for example, or Biden in 2020. And so that sort of gerrymandering is a sign of what is wrong with our democracy, but the courts have been instrumental in that. And with the Wisconsin Supreme Court, because of the way it has been constituted, has played a significant role in using their judicial power to change the rules to make it harder for us to have fair representation in Wisconsin, fair maps in Wisconsin, which everyone really should support, no matter their party, no matter their background. We should have fair maps and a fair shot at representation. So I'm going to end my presentation. I think I'm right on time, but I'm going to end my presentation on a positive note, perhaps. So we've been tracking these different groups in different states, how they spend money, how they're deployed, and Arkansas provides a very interesting case study for how judicial candidate fought back and how other watchdogs helped support or protect fair courts. And so you can see from the slide, back in 2019, Judicial Crisis Network / Republican State Leadership Committee spent more than $3 million trying to unseat a sitting Supreme Court justice in Arkansas. And she herself made dark money a central theme of her campaign. She called out her opponent for his ties to this dark money network, repeatedly brought up his dark money support in interviews, and she also sued over those misleading ads. She didn't just let the newspapers decide whether to do a fact check, but when the groups against her ran misleading ads, she directly responded to them. But she wasn't alone. There was also an effort called the Arkansas Judicial Campaign Conduct and Education Committee's Rapid Response Team, which included former judges who publicly condemned those smears. And so there was an effort to have news coverage of what was happening, because so often what I've seen over these past 10, 12 years as I've been in Wisconsin is a dark money ad campaign will go up, and you can't run ads that follow that ad saying, hey, that ad was misleading, or hey, who's that group? It's just not possible to confront it in real time. So you're reliant on the news media to tell the American people, tell the people in Wisconsin who's behind those ads or whether they're accurate or not. And they could do that, reporters do that. But in the case of Arkansas, they were able to have an independent, nonpartisan rapid response team that was focused on making sure newspapers across the state, radio stations and TV stations understood what was happening and understood how misleading those attacks were. So with that, I will conclude. Here's our contact information, and I will now stop sharing the screen. Thank you so much for your attention and time. And I know there may be questions and other responses.
Thank you so much, Lisa. My head is still spinning around all of this, so I appreciate folks who've already submitted questions, and feel free to type in questions as we have this conversation. Ellen?
I'd like to ask a question of Lisa.
Yes.
So Lisa, your presentation focused on the dark money coming in from what I'll call the conservative side, correctly or incorrectly, the liberal side. Are they doing the same thing? Are they just not as good at doing it? Is that something we should be concerned about as well?
Well, a couple things, Ellen, and I appreciate that question very much. So we did include the outside spending in that slide about what the Greater Wisconsin Committee or other similar groups were spending in those races. So you can see that outside money regardless of its source. The biggest one, we didn't include it exhaustively because it would take over the entire screen. But they have spent money in elections and have spent in some instances a similar amount, sometimes more, sometimes less than the RSLC operation or the WAR operation in the state. A couple things about that. One is that some of that money is money from labor, meaning it's money from a large range of individuals that are small donors that they check off a box to allow their union to spend money to defend things like worker rights or to defend against judges who are perceived as being hostile to worker rights. And so we know because a substantial, or at least what we believe to be a substantial amount of the money that has come into Greater Wisconsin has come from labor, but that money is money that is coming from a lot of individuals. In contrast, we know quite well that some of the big money coming into Fair Courts America is from Uline, not from thousands of workers or tens of thousands of workers, but from one super rich guy in particular, who's passing that money from his restoration PAC into the Fair Courts America operation. The second thing is, I would say, and I don't want to put words in the mouth of the league, but I would suspect that you would agree with me that we should have reform of dark money across the board. I supported that in my testimony before the United States Senate Judiciary Committee on behalf of the Center for Media Democracy, and in my work. We need to reform what the Supreme Court has done. This unleashing of all of this money that people don't know who the sources are, or the most significant sources are, for money that's being directly used to influence elections. That's just wrong, and it really is undermining our democracy. And so I definitely support rules, and have publicly supported rules that would apply across the board, no matter the group, that would require the disclosure of the biggest donations. And so has Senator Whitehouse, and so have members of the Democratic Party in the Senate and the House in Congress. But they've been stopped at every turn, even to get disclosure, let alone like a bar or limits on the amounts, even to get disclosure of those biggest amounts by a concerted, consolidated Republican Party at the federal level, who has stopped that sort of disclosure. In Wisconsin, what we've seen, for example, is a parallel in essence. You have the Wisconsin legislature not responding to the many referenda in Wisconsin about overturning Citizens United, about restoring transparency to our laws, instead responding by barring the Wisconsin's election board from policing elections the way they were trying to address this coordination. They changed the rules to allow coordination by these groups, including basically ratifying what was being done that was being criminally investigated before. And there have been efforts to basically even change for campaign disclosure, whether you know who the employer of a donor is. Now that's for a campaign donation. So in Wisconsin, there was a criminal investigation because there was a Republican railroad magnate, or at least had money from the railroad industry, who was using straw donors and basically had his employees donate to candidates in Wisconsin or campaigns. And the reason that it was investigated was because there was suddenly there was a huge amount of donations by this person's employees, and it turned out that they were straw donors, and he was that was really him posturing through them. And so what did the Wisconsin Republican leadership in the State House, the Assembly, and the Senate do? They went after the idea that we should be able to know who the employers of disclosed donations are. And so it's not partisan, in my view, to describe that reality, which is that we have a leadership in Wisconsin's legislature that is hostile to disclosure, hostile to protecting against the way dark money can distort our elections, and has actively changed the laws to make it darker, to give greater permission for that sort of activity.
Thank you.
Lisa, can you describe, I think that you've referred to this before as well, but some of these changes, it seems, if the Supreme Court has ruled one way, the only way to affect that would be to pass legislation at the federal level. Can you just, because for those folks who are trying to understand the role of the court versus executive and legislative branches, so if we're looking at trying to reverse decisions made by the Supreme Court that people may feel are anti-democratic, the only way to do that is through federal legislation. Is that correct?
Well, I really appreciate the question, Robin, and I think there's there are ways in which there's not a clear answer to that question. So it's a great question, and let me try to explain from my perspective a couple things. So one is, for example, with the Citizens United decision, that was a decision by the U.S. Supreme Court to forbid Congress from putting limits on the spending of money right before an election. These are in federal elections. So what it did was it attacked what was known as the McCain-Feingold Law, which was the Bipartisan Campaign Reform Act. And instead of the court ruling on it as a statutory matter, like basically saying this statute is invalid or this statute, is overbroad. What it did was it reframed it at the behest of the proponents of those changes as a constitutional issue, that regulating the spending of money before the election, even requiring disclosure of the major donors right before the election, violated the First Amendment free speech rights of the money spenders to be secret. And so in that case, that's why there's been an effort by a lot of people, including me, to support a constitutional amendment, which I know is a huge lift. But because the Supreme Court made it a constitutional ruling, that requires a constitutional amendment. Now, it's also possible, as we've seen with this current US Supreme Court, that if there were different members on the Supreme Court, they might reconsider that case. And now it seems to be a free-for-all, since this court seems to consider no prior precedents to be very binding or to have any real substantial weight at all. So that's another mechanism. But then what happened was that those cases were going down to the state Supreme Court. Could they then have a separate rule? Could you have a separate rule under your own Wisconsin Supreme Court or Wisconsin Constitution or Montana Constitution? So there were opportunities at the state level. Those have been shut down by state Supreme Courts. As I think you can see when you look at the language that was used around those changes to the rules to allow the type of dark money coordination that was being investigated in the John Doe 2 investigation. But secondly, there are cases where it's both constitutional and statutory. So take the Dobbs case, for example. In that case, you have an effort by the Right to Life anti-choice community to overturn Roe versus Wade. And so what they were arguing was there should not be federal constitutional protection for women to access abortion. And so the Supreme Court overturned Roe, and in its decision said this will leave this to the states to decide. So in that instance, you have the US Supreme Court saying, they're not banning abortion per se, they're just, quote, leaving it to the states. And then meanwhile, the groups that were behind that decision are actively pushing for, one, a federal statute barring abortion nationwide. And then in each of the states, working either to affect who is on the state Supreme Court, who the Attorney General is, what the state legislature says about Roe, and whether people will have access to abortion in their state for, during the first trimester or second trimester, or if they've been raped or victims of incest or what have you. So in that instance, that's where there can be state action in response to a Supreme Court decision. And then I'll just take a third example just to kind of close the sort of loop on it. Then you have situations like with redistricting, where the US Supreme Court has intervened to, or let me take the voting rights case. So the Voting Rights Act, in that case, the Supreme Court by John Roberts decided that, notwithstanding the fact that Congress had reauthorized the Voting Rights Act for 25 more years in 2007, that he himself, a longtime opponent since the Reagan administration of the Voting Rights Act, would overrule that congressional determination and say, we no longer needed those remedies to prevent from the suppression of the vote in America, that America was somehow post-racial in some sort of way, which we're obviously not. And that's a case where Congress could itself, if it had the votes in the House and the Senate and could overcome the filibuster, could repair that and restore those rights. Similarly, in Wisconsin, on the maps, if there were a legislature that could ever overcome the gerrymandered legislative maps, that legislature could create fair maps again. Or a different Wisconsin Supreme Court, if it found that prior ruling was in excess of the court's power, was an invention, this minimal change notion that came out of just the blue, they could change it. But I guess the last thing I'll say just briefly is one of the most interesting things in Wisconsin and elsewhere is the interplay between the anti-choice groups and the campaign finance groups. So in Wisconsin, for a number of years prior to Citizens United, Wisconsin Right to Life, whose lawyer was James Bopp, was attacking Wisconsin election rules. Then James Bopp helped orchestrate the Citizens United decision. And he didn't argue it, but he was heavily involved in pushing that forward to attack campaign finance laws. And so what you have is in Wisconsin and other places, how these sort of right-wing hot button social issues have been married with these efforts to attack basic campaign finance laws in order to allow that social issue to predominate, and in fact to put people on the courts, for instance, the US Supreme Court level, that are hostile to those very rights. So that dark money has had a substantive impact. And how do you overcome that? It's very complicated because it depends on whether it's framed as a constitutional question or a statutory question or a federal question versus a leave it to the states question. Sorry for that long answer. That's best I can do.
No, that's awesome. Thank you. So we have a question about broadcasters and the fact that they are publicly licensed to broadcast. Is there any ability to put restrictions or conditions or fact checks or anything with respect to the cost of ads, the number of ads, or the content of the ads? Is that something that can be regulated per se to kind of avoid what's happening, like you said, at that last minute influx of ads that are often highly misleading and perhaps not factually accurate?
Well, there's a couple components there, and I thank you so much, listener, for the question. First of all, there was a rule that was adopted by the FCC a couple years back, might have been 2016 or before, which did require the disclosure of the money being purchased in major media markets. So it sort of depended on what counted as a major media market, whether a certain type of disclosure was required. That was a procedural requirement. It didn't require it wasn't about the content of those ads or whether they were accurate. It was just trying to force groups that had FCC licenses that were large scale to provide some real-time information to the American people about where this money was coming from. But the second part is that the internet companies, in essence, Facebook, Twitter, Google, don't count under the current definitions of how we understand or how we think of our airwaves. They don't count as FCC regulated entities. So they are not subject to even that minimal amount of disclosure of the purchasing of ads in major media markets. And there's in fact been a lot of resistance by big tech to being regulated under the FCC, even though it is the transmission of this content over our airwaves that makes their companies possible. Like but that has not happened. And then the third piece of that, which is related, is that a substantial number of these ads, as far as we can discern, are coming through social media. Our pop-up ad on YouTube or on your browser that's a sort of a geolocation ad targeting you as a Wisconsinite. On Facebook, there are ads that can target you based on whether you love soccer or your kids in or you love Rachel Maddow or you love Tucker Carlson or whatever. Whether you're a fan, you can do very precise targeting. Now, Facebook does require through its ad library people to be able to see those ads and see how much was purchased and see the general scope of those targets. But if you're not the target of that ad in real time, like you're not going to see that ad, you would have to go to the library to see it. But Facebook is almost alone in providing that sort of data in near real time about its spending. And that leaves the other social media companies to their own systems of whether they're going to allow such ads, whether they're going to, or election ads. For a while, for example, Twitter had stopped certain types of ads right before the election, but will it do that again? Seems unlikely. Did it ever have a good ad library for you to see the targeting or the money? No. And so we have a highly unregulated environment that is being used very deliberately by a highly unregulated dark money set of operations.
Okay, wow, great answer. Thank you so much. We have another question that refers back to the discussion you said about the rapid response group in Arkansas forming. Was that an independent? Was it partisan? Like, who started that? Can you give us some background on how that was initiated?
That was a nonpartisan effort. Evan, I don't know if you feel comfortable answering that, or I can take a whack. But if you want to respond, I know you've looked deeply at it.
Yeah. So it was formed in 2016, a nonpartisan 501c3, and it comprised of sort of like a who's who in the Arkansas legal community, a lot of former justices, their staff, attorneys, and it was directly in response to some of these like very misleading high dollar judicial campaigns in like 2012 and 2014. They saw a lot of this outside money come in, these like highly misleading ads, and so they formed this as a way to sort of combat it.
Thanks, Evan. That's Evan Vorpal from our True North research team. Thank you so much, Evan.
And do you see any signs of a group like that forming in Wisconsin, or would you not really know about it quite yet?
We haven't seen a C3 created specifically for that purpose. We have seen a tremendous nonpartisan effort that Wisconsin Common Cause has helped support by judges and former judges across the state to support new recusal rules in Wisconsin, to make sure that there are better recusal rules than the rules that Wisconsin Manufacturing and Commerce got the sort of, in my view, captured Wisconsin Supreme Court to adopt, which allowed these justices to continue to participate in cases where the groups that helped get them on the bench were active litigants and participants. So that is an example in Wisconsin where there has been, and that was I think almost exclusively, or in fact exclusively, former judges, that where they came together as a in a unified way to say that we can't have a system where you don't have fair recusal rules. It really undermines justice and the appearance of justice in the state. I think that it would be fascinating if there were former judges who were in touch with those Arkansas judges to understand how they set up their efforts and how they acted in a nonpartisan way to try to protect the integrity of the election, and to protect people from being, to the best of their ability, swayed by disinformation, by misleading ads, because clearly the folks in Wisconsin or in Arkansas did a lot of work to make sure that they would have a nonpartisan effort in that regard.
Wonderful, thank you. Another question. So you noted that a lot of these ads are really being targeted at the end of the campaign season, so right before the election. And I'm wondering whether or not the increased rates of early voting is offsetting that at all, and whether or not I can understand where there could be perhaps restrictions put on early voting if the outcome is reflecting that, but what your thoughts are on the impacts of, I guess, not only early voting, but we've seen significant increase in this area in student voting as well. And I know they obviously are probably more linked to social media, but I'm just curious to your thoughts as to those two influences.
Oh, thanks, Robin. You know, I actually don't know the proportion of early voting in the spring elections. I have a general sense of it in the even year elections in the fall, kind of how early voting or absentee voting has happened in Wisconsin. But I don't know kind of what that proportion is. It certainly is the case, though, just temporally, if the cash bomb, like the RCC cash bomb, comes in on day 8 before the election, it would not affect people who voted before then. But it is, it does appear to be very focused on social media. And so is would be likely, although we don't know because there's a lot of this dark money spending that goes on, really below the scenes, that, could very well be targeting students. And I know in Wisconsin, there has been, a specific effort, as I think many of you all have observed over time, to make it harder for students to vote in the first place. One of the shocking things I recall from 2012 was a story by the late Pam Lautenschlager, who talked about how her daughter went to register to vote, but didn't have her driver's license, but a fishing license could have been used. I think they would end up going to get a fishing license, if I'm not mistaken, because it was easier to get that day than a driver's license or something based on where they were. But the gist of it was that there were exceptions for fishing and hunting licenses to be able to vote, but not for student ID. And so for students, as you know, students often change dorms by semester or by year. They'll often leave their driver's license at their house where like kind of all their main mail goes. And so the student IDs in Wisconsin, at UW, in Madison and La Crosse didn't have their address, their physical address on, but they previously had been able to vote by, showing up, at the polling place. And if there was a question, they could show their lease or something, so that they actually live there, live in the city or that precinct. And then the Wisconsin legislature, dominated by Republicans and signed into law by Scott Walker, changed the rules so that those student IDs wouldn't work. You couldn't use your student ID. And it was premised on a completely outlandish notion that students were somehow voting twice, going home to Green Bay, voting there, coming back to Madison and voting. No evidence of that whatsoever, just a deliberate effort to try to chill the student vote. And that is a common strategy. We, I think, saw similar things in Texas, where a hunting license or a gun license would count, but not a gun license, but a hunting license or something would count, but not a student ID. And those measures to make it harder to vote, I just feel compelled to say, were prioritized by the American Legislative Exchange Council, a group that I helped expose starting in 2011 through alecexposed.org. And what happened was, there were some voter ID measures that were kicking around the country. And then after Barack Obama was elected in 2008, in part based on a substantial turnout by students and also people of color and people of color living in cities, ALEC at its 2009 meeting decided to make changing voter IDs and making them more restrictive one of its top priorities. And it did so at an ALEC task force meeting that was co-chaired by the National Rifle Association. The National Rifle Association and other corporate funders voted on those measures to make it harder for people to vote. And then those measures were picked up in Wisconsin and other states and passed in the law. And they've been, passed since then, and new versions of them have been moved in the last couple of years in these different state legislatures to make it harder for people to vote. In Wisconsin and in North Carolina, there was substantial evidence, and judges agreed with this, that advocacy, that there was substantial evidence that this was also a racial effort, an effort to suppress the vote by African Americans, make it harder for people to vote, and that was sort of an express component of those measures was to do so. But the other part of that story is these claims about voter fraud have been around now intensively for almost 2 decades. Karl Rove was central to try to move forward a narrative of voter fraud. They removed a number of U.S. attorneys in states across the country because they weren't playing ball on suggesting that there was a voter fraud problem. Then you see this effort to use so-called voter fraud to attack Wisconsin's voting rules, even after JB, I can't even think of his name now, but the former AG
Van Hollen.
Van Hollen at the time had done a blue ribbon panel that found there was no systematic voter fraud in Wisconsin, nothing that would warrant these sorts of changes. They disregarded that and passed these measures. And then coming forward to this past few years, you see this narrative of voter fraud, of being so dominant in our election, despite the lack of evidence. And so sorry to go into that long detail, but it really is another way in which there's been an effort to change the procedures, the rules, in order to distort and torque our system of government to make it harder for, who wants to make it harder for Americans to vote? It's so antithetical, and yet they've been so successful in imbuing this notion of fraud as so omnipresent, when every single study that looks at it in Wisconsin and elsewhere finds it is not real, not real.
So I think we have 2 more questions, and then we'll close this out. I think the first question is, obviously there's a lot of concern about the Supreme Court in the Dobbs Roe v. Wade situation, and I think that people are becoming more aware of the importance of these, both the state and the U.S. Supreme Court. And I'm wondering if you're seeing evidence that that issue may drive more people to become more aware of the importance of state Supreme Court elections.
I think that's true. It certainly was a wake-up call for a lot of people that the court would behave in such an extraordinary way, the Supreme Court, U.S. Supreme Court, to overrule decades of precedent that is strongly supported by the American people. People support there being access to abortion as a kind of a basic thing in our society, and the idea that that precedent had been around for so long could just be overturned because the people on the court changed, not because the law changed, not because the circumstances changed, but just because of personnel. Really, I think, woke up a lot of people. There were a lot of people who were already awake and already concerned and very worried about it, but there were others who, weren't really paying attention to the court. But who has been paying attention to the court? Leonard Leo. And he's been focused on the state Supreme Courts, we know, for at least 2 decades now, at least since 2001. He's been actively involved in money involving Wisconsin Supreme Court since 2011, as we showed in this presentation. So the sort of right wing, or what some people call conservatives, have been really focused very heavily on the Supreme Court, U.S. Supreme Court, and the state Supreme Courts, in a way of this idea that personnel is policy, that they are trying to move people into those positions. If you look at the origin story of the Federal Society, going back to 1981, actually there was a story in the New York Times in '87 where they basically talked about how a decade or so from then, their people would be in key positions all around our government, in court judicial positions as well as other positions. So their objective has always been to put people who have their point of view, which is one that is hostile to the bulk of legal precedents around our rights in the 20th century, in my view, into key positions of power. Part of that, was very focused on Roe, even though the Federal Society says it doesn't take a position on issues, that it's a debating society, that it just has these working groups. When you look at the activities of the key leaders of the Federal Society, including Leonard Leo, but also some of these people that they promoted to the bench and that they've applauded for their confirmation at their conventions and the like, there are people who have a record of hostility toward women's rights, a record of hostility toward equality, modern conceptions of equality rights, as well as to regulating corporations in ways that advance the interests of the ordinary person to have clean air, to mitigate climate change and more. And so there is a return on investment. People who are like Barry Side, this billionaire 90-something-year-old guy from Chicago, he has invested this money with Leonard Leo to get changes, to change America. Not to keep America the same, in terms of the legal precedents that are out there, but to change America in ways that I think a lot of people would, do not support and would not support this idea that no one has seen the type of revolution since before the New Deal, back to the robber baron era, or as the lawyers know, the Lochner era, where courts were striking down social justice legislation, wages and hours legislation, anti-discrimination measures, because they were supposedly infringing on freedom of contract and some sort of invention that contract was greater than our Constitution or the promises of our Constitution. It's astounding, but that is the agenda that Leo and many of the people that he has supported have laid out. They've set forth an agenda that is very hostile to government. And as Nancy McLean calls it, chains on democracy. A lot of these groups have, as part of their mantra, limited government, including ALEC. When I was examining that before Nancy's book came out, I was like, oh, it's not limited government, it's limited democracy. It limits our ability to have a full and expansive democracy, and limits the ability of the power of that democracy to set rules to limit the power of the richest few. Which Nancy, in her independent investigation, really accurately described domestically and internationally as an effort to put chains on democracy. When democracy is chained or enchained, that empowers people who have more money to have more power over our law.
And I apologize, I did not see other questions that were here, and I don't want to have this too long of a session, but I'm wondering if you could just take a minute and explain how your organization is funded. And I believe you said that you were a nonprofit. Could we just get some clarification on that?
Well, sure. So we are a nonprofit. We're not a tax exempt nonprofit. We're a small organization, and our budget is less than $600,000 a year. And it is all small family foundations that support our work.
And are you aware of,
Robin,
I'm sorry. Are you aware,
Robin, this was,
I think
go
that was-
ahead, Robin. I'm sorry.
So another question is, are you aware of any efforts by Wisconsin judges to push back on dark money in judicial elections? Is there any talk that you're aware of by judges or organizing by judges now?
I don't know, because I'm not involved in that sort of work. And which I guess goes to your earlier point, which is, in the support that I have done at the United States Senate and more, what we've urged is that for groups that are actively involved in running ads in elections, that they should be treated like the way the candidates and campaigns are. They should be subject to rules involving their real-time disclosure. There are a lot of nonprofits, a lot of groups out in the world, hospitals, universities, Red Cross, et cetera, that are not actively involved in elections. And so the kind of interests of their donors or their donors, we're not trying to destroy, all the ability of any group to have someone make an anonymous donation. But when that group is actively involved in elections, in electioneering, or in ads that are designed to target voters to affect the outcome of that election, I think people have a right to know. The premise of having campaign finance laws of the Federal Election Campaign Act and the Wisconsin equivalents is that there is an inherent concern of corruption. If people are playing a substantial role getting people in office, there is a sense of potential obligation. And when it comes to judges, there's an inherent concern about the impartiality of justice. If someone very powerful has played a key role, or a group that's very powerful has played a key role in getting those justices in office, that is important, I think, for the people to know, which is why when I was leading the Center for Media Democracy, we submitted an amicus brief in the case involving the John Doe 2 investigation and the recusal question in support of the prosecutors, because we thought that some of those Supreme Court justices in Wisconsin should not be sitting on that case, because they themselves were beneficiaries of some of the spending by the very groups that were under criminal investigation in Wisconsin. But unfortunately, this US Supreme Court did not take that case. So I just want to differentiate that position on, on the transparency and the imperative of transparency. If you're running ads to affect the outcome of the election, everyone, not just one side or another, who's doing that should be disclosing who their major donors are, just like a candidate or a campaign would have to.
Right, thank you. I think we are going to go ahead and conclude this program. I want to personally thank you, Lisa, so much for all the information you provided us, and we will have this recording of this on our website, I believe LWVLacrosse.org, very shortly. Usually we get them up within a day, so that if folks want to refer to this or share this, it's on a YouTube channel. We're happy to share this with our other leagues as well. I want to thank Ellen and Deb Luchin and the entire program committee for your work in getting Lisa and all of the programs that